All right. So this is a subject that I've been doing some work on recently. I think it's kind of interesting. So anyway, here we go. These things, whoops, these things have a very long history in common law countries. Of course, the United States is a common law country. We inherit a lot of our default laws um, from the English. So oaths of office are one of those just sort of basic bits of legal architecture that goes way, way back. I did some digging in the last week and a half here, and the oldest one that I was able to find was from the year 975, when Edgar was crowned King of the English. And he promised some pretty wild stuff by our standards. He promised to outlaw robbery. I guess they hadn't done that yet. Anyway, uh, so of course, I'm talking about this because this tradition was carried by the colonists to the New World. Um, and in the American context, one of the interesting things about it is the first really American oath of office actually predates the Republic. It predates the Declaration of Independence too. That's the 1775 oath of office for the Continental Army. Of course, the older traditions, the swearing allegiance to the king and crown and all that, were obviously no good once we've set up a new republic. So Congress, being Congress, dithered and fought about it for a while, but eventually they settled on a formulation for a new oath, and that was pretty much what you see down to this day, with modifications. The formulation that they settled on was, "I do solemnly swear or affirm that I will support the Constitution of the United States." Now, Minnesota has added a little bit to this. Most states have by now. Minnesota continues this tradition today for basically every public office. Not aware of any that don't have this. So for most people, the source of authority comes from Article 5, Section 6 of the Minnesota State Constitution. And that provides that each officer created by this article, that is to say, people who are not actually state legislators, state legislators get their own special oath. Everybody who's not a state legislator has to take an oath or affirmation to support the Constitution of the United States and of this state, and to discharge faithfully the duties of his office to the best of his judgment and ability. Now, of course, the reason I'm talking about this is because this applies to townships too. And as so often, there is Pat has asked, what's the difference between swear and affirm? So this is something that will come up every once in a while. There are particular religious groups, the ones that I believe it's Seventh-day Adventists. You'll see it there. Some denominations of Baptists do this too, and I believe Quakers as well actually have a religious objection to swearing oaths. And so, we, being the United States, we try to accommodate that, and we try to make it okay for you to abide by your conscience as a general rule. And so we offer this other formulation, which is affirming it, which is not, legally speaking, there's no actual difference. But the idea is to help somebody whose religion tells them they are not allowed to swear an oath, to let them be in office too. So the formulation is a little bit different. You're going to say, "I affirm this" instead of "I swear this," but legally speaking, there is no distinction. So as so often with townships, we get our own special statute, but then the general statute also applies to us. So special for us, Minnesota statutes 367.25 subdivision 1 is in our special chapter on townships, our special chapters on townships. And that's the one that I think provides the basic guideline for us. Every person elected at a March election, special election, or appointed to a town office shall take and subscribe the oath required by law. Persons elected at a November election shall take their oath before assuming office. Now, there's also the general provision, which is Minnesota Statute 358.05. Every person elected or appointed to any other public office that is not the legislature, before transacting any business or exercising any of the privileges of that office, They're supposed to take and subscribe the oath defined in the Constitution of Minnesota, Article 5, Section 6, the one that we talked about earlier. So Minnesota has created this weird kind of bifurcated timeline here, at least for township officers specifically. So November people are special for some reason. Everybody else has to take it within 10 days, basically. So the rule is 10 days after you receive your certificate of election, if you were elected in March, if you were appointed, if you were elected in a special election. But November people, all they have to do is, quote, before assuming office. Now, little bit, I apparently put my slides a little out of order here. So our oath has, or our affirmation, as the case may be, has 3 parts to it to make it work. You have to affirm that or swear that you're going to support the Constitution of the United States, support the Constitution of Minnesota, and then do your job faithfully and to the best of your abilities. That's the way to do it. So what happens after you've taken it? Well, then the next step is to file it. So the rule is you have to file it, quote, before entering upon your duties. That's our Minnesota Statute 367.25 again. There's a special rule about fees. So town clerk is supposed to administer it without and certify it without a fee if they're doing it if they're doing it for their own township officers. This is one of the reasons that we advise township clerks to go ahead and exercise their powers as an ex officio notary, because it just makes things way more convenient, right? If you go through and you get the little stamp, then you get to just kind of print out your own oath, stamp it. There you go, bing, bang, boom, done. Now there are potential problems if you start without filing. Fairly clearly, I would say there's a penalty of $50 that goes to the township if you enter upon your office without having taken the oath or affirmation and filing it with the town clerk. That one seems to me to be pretty valid. That's also coming from 367.25. There is at least theoretically the possibility that there's technical criminal liability attaching to that. That is the illegal assumption of office. There is a criminal statute saying you can't illegally assume an office. As a former criminal practitioner, there's about 1 million defenses to that for a normal case. But I would be remiss if I didn't let you guys know that a particularly aggressive county attorney could theoretically turn this on somebody who hasn't taken the oath. Now, I've never heard of such a case. I wasn't able to locate one despite looking for quite a while. I think this is more theoretical than real. But hey, look, it's my job to be a Debbie Downer and to let you guys know what could possibly go wrong. So that is one of the things that could possibly go wrong. Speaking of other things that could possibly go wrong, what happens if you just don't do it? Minnesota law, in my view, is fairly clear on this point. So there are 2 different statutes. Thank you, Pat. I appreciate the laugh. There are 2 different statutes that I would say are fairly clear that what happens is the office becomes vacant. Same thing as an automatic resignation, and that's coming from our old friend 367.25. Subdivision 2 of which says that if you don't file it within the time required, that is 10 days if you're normal, and before assuming office if you're November, that shall be deemed a refusal to serve. Aside from that, there's also the vacancy in office statute, which I think is a little bit harsher, if anything. That's 351.02 in parens 6. It's not a subdivision, it's in parens. Sometimes the legislature does it in weird ways. Every office shall become vacant upon the incumbent's refusal or neglect to take the oath of office, to give or renew the official bond, or to deposit or file such oath within the time prescribed. Now that one's automatic, and in almost every other context. So traditionally, the context in which that statute comes up in is what happens if my township clerk or if one of the other supervisors, what happens if they move away? Well, we tend to take the view that in that case, it's an automatic resignation. The office is automatically vacant and the board can't really do anything about it except appoint somebody. This is one of the other subdivisions within that statute. So I think it's the same thing. Now, once again, here I am trying to make sure that you guys understand the lay of the land. There is contrary authority out there, but I don't think that it's actually, I wouldn't bet my head on it if it were me. So here's the situation. The Attorney General of Minnesota issued an opinion in 1951. And an attorney general opinion is not the same thing as law. It's not like an opinion from the Court of Appeals or the Supreme Court, but it is persuasive. And in a lot of cases, that's the sort of guidance that we rely on, especially as a governmental entity, because we try to keep our fights below the point where people are in the Supreme Court, right? But anyway, in 1951, Minnesota Attorney General says, failure to take the oath of office within the time specified does not ipso facto create a vacancy if the qualification is done before the steps are taken to declare a vacancy. So the reason that I think that that's probably not correct, at least not today, is, one, it's a very old decision, but two, it deals only with 367.25, which does kind of talk in terms of voluntary actions from the board. It doesn't deal with this other problem of 351.02, which seems to require no actions at all and seems to sort of automatically go to declaring a vacancy. So I tend to think that authority is probably not good anymore. But just so you know, it's out there, which means that you do have, if you happen to step on this rake, at least you've got the one argument, right? Which is one of the reasons that as an old criminal practitioner, I think that you're probably not ever going to get charged with this, because you can always look to this opinion and say, hey, look, I didn't think I was doing anything wrong. I was just following the Attorney General of Minnesota's advice. And as a prosecutor, I wouldn't want to take that case. I'll put it that way. Okay. So that is pretty much the oath of office presentation that I had here. I see a hand there. Larry, do you have a question? Larry, if you if that hand was intentional, I'm showing you as muted still. So let us know if you've got a question. You just unmute and ask it, or type it if you prefer.
No, that's okay. It was an extra accidental bump.
Gotcha. I have certainly done that myself. No judgment. All right. Does anybody have any questions about oath of offices? Anything related to that? All right. Nope. Pat, I see your hand.
Yeah, I do have a question. So on the oath of offices, you say we file them. Are they just filed here in my office, or are they sent to you guys?
Well, so statute talks about filing with the town clerk. So I think that's what's required. Certainly, I don't think there's anything wrong with filing them other places. It could be helpful to help find them again later. I'm not sure that we have the capacity to, let me get back to you on that one. I bet we could figure something out in terms of that. But
well,
bottom line, from legal perspective, what's it?
I said, because it's like our resolutions. We do a resolution here, and then we send it into the law library.
Yeah, pretty much.
So it's filed there. I don't know what they do with it, but
basically the point is that John Q. Citizen, who's like, I'm not sure about this guy, is supposed to be able to look it up and see that they're legit, right? So yeah, I would say law library, I would say town clerk's office, same place you keep your resolutions and your ordinances, essentially. Reno, see you've got a hand up. Just saw the county auditor. I think it's a good idea Well, I would say county law library is a good idea. Just to be clear, the statute talks in terms of filing with the town clerk. So I would say that that is all that's required. But more public access is good. I don't think it's in any sense wrong to file it with the county law library. I think if you want to be belt and suspenders conservative about these things, which it usually is good as a two different ways of making sure your pants don't fall down, right? It's filing with the county law library so that people can get access to them is probably a good idea. Now, of course, that involves a conversation with your county law library administrator and assuming that they'll take it. But if they take your ordinances and they are required to, then they should take this sort of thing as well, in my view. Now, Reno, did you have a question? I saw your hand was up, but I couldn't quite hear.
No, Graham, I'm fine. Thank you so much.
Gotcha. All right. Well, since it is post-annual meeting and everybody is still sort of recovering and digging out from all the questions that came in while we were all in St. Cloud, going to be a bit of more of an attenuated meeting this morning. But that is all I had for folks. So thank you so much for attending. I hope you got something out of the presentation. Let me know if you want a copy of it. Otherwise, have a good morning, everyone.